would have had to get out of Ronny Walker's car while he's driving and commit the murder outside of his car. At that point, Ronny Walker should have and could have driven away and fled from that scene, but he did not. He waited until the defendant got back into the car and then started the car and not just fled, then he turned off his lights in order to assist and aid in the getting away, clearly showing, circumstantially at least, Judge, that Ronny Walker had an intent that this crime be committed or be successfully accomplished. Okay, there is no way they was sufficiently established that she was shot.
Back, hold on, I misunderstood. Yes. Go back to the beginning of that argument. Who got out of the car and shot?
According to the defense, if you want to believe the defense, right, it had to have been Robert Creed because they were the only two people in the car. So if Robert Creed got out of that car and shot, Ronny Walker then waited for him to get back in the car.
There's no evidence of that.
Yes, there is, Judge, because the shots. She was shot outside the car. For sure, she was killed outside.
There is no evidence that Creed shot. Yeah,
if
they were the only two people there.
But that's what they're arguing.
Why couldn't you just go beyond your argument and say, you know, there was a third person there waiting to kill her, and they just delivered her there?
Judge,
you can say anything you want, but there's no evidence that Creed shot anybody.
I'm saying this to rebut their argument, Judge. If they make that argument that Creed did it,
what they say is not evidence.
I understand, but then we should be able to argue two alternative theories, as the court is well aware, which is that even if
you have to have evidence to convict someone, not argument.
Judge, we do. Circumstantially, we have proven that Ronny Walker was the driver of the vehicle.
You think you proved that Ronny Walker? You're trying to prove now, circumstantially, that Creed was the shooter?
No. I'm not proving that Creed was the shooter. I'm saying that even if Creed was the shooter, Ronny Walker assisted, aided, and abetted him in committing this crime.
There's no proof of that.
Judge, he drove to this location. The only person who drove to that location was Ronny Walker.
Yes.
So he knew that something bad was going to happen, because why would you take a young 14-year-old girl to a vacant field in a dead-end lot unless you know that that person's going to be killed?
Are you alleging under the principal theory, I'm going to let you finish, but I just want to make sure that I'm thinking along the same line as you. Are you saying that for the principal theory to be correct, that Creed shot the girl and Ronny Walker's the principal to that?
I'm saying if that's going to be their argument, we should be allowed to rebut that and say...
I'm not asking you if that's their argument. Are you saying that Creed shot the girl? If you're going to argue, the principal theory to the jury, then you have to believe that Ronny Walker is not the shooter and Creed is the shooter. Yes or no?
Judge, no. We can argue two alternative theories.
I'm not saying you can't argue two, but to argue that one, you have to say Creed was the shooter. Yes or no?
I can say yes. You know, ladies and gentlemen, if you believe Creed was the shooter, guess what? Ronny Walker was just as involved because he aided and abetted.
Creed was the shooter. And don't say it's because there were only two people there, because that's not evidence.
Judge, do you understand that we have to be able to rebut their defense? Their defense is there's only two people in the vehicle, so their defense is going to be that Robert Creed was the shooter. We should be allowed, as the state of Florida, to argue that even if you believe that, and the state is not arguing that that's the case, but even if you believe that, even if crazily you believe that Robert Creed got out of that car and did that shooting, Ronny Walker was at the very minimum an assistant, aider, and abettor in committing this murder, which means he is a principal under the theory.
In what capacity?
As the driver, Judge, as the person who took this victim
to what crime?
To murder.
By who?
By either.
Show me the evidence that either, i.e. Creed, did anything regarding the murder. Except
I don't have to show you that evidence. We as a state have a right to argue alternative theories.
You have to show the jury the evidence.
They're going to argue that evidence, Judge. They're going to argue that They're going to argue that Robert Creed had her phone number in his phone.
I know what they're going to argue. It's obvious.
So we should have the ability to rebut that and argue under the circumstances.
You can't argue facts.
Judge, the only reason Ronny Walker was initially charged in this case was under the principal theory. To take that away from the state, you're basically taking this whole case away, because now
your whole case, since jury selection till today, has been that guy over there, the last name of Walker, shot and killed this girl. That's been your entire case. Not one time have you put on any evidence that Creed was the shooter. Never. Until
Judge,
now.
We don't have to. We're not supposed to put on
evidence. You do have to. You have to prove your case beyond and to the exclusion of every reasonable doubt.
Correct.
Based on the evidence.
Correct.
And I haven't seen a single piece of evidence that says Creed's the shooter.
It doesn't matter, Judge, but they make that argument. We can argue that he was
It doesn't matter. The state has provided no evidence of Creed's guilt.
All right, if I can just finish putting my stuff on the record. I'm also going to cite 675 Southern 2nd 196 TSV State. Again, while it is settled that mere presence at the scene, knowledge of the crime, and flight are insufficient to justify a conviction, it is also clear that elements of assistance of the perpetrator in intent may be proved by a combination of surrounding circumstances. And we are arguing that there are these surrounding circumstances, Judge. We also provided Lewis v. State, which I know the court has already cited, so we would also rely on that. And Judge, it is the state's position that while we do not believe Creed was the shooter in any manner, if the defense is going to argue that, we should be allowed to rebut that and argue that even if the jury were to believe that, even if the jury were to say, well, we're not convinced Ronny Walker did the shooting, we can still be convinced that Ronny Walker assisted in the murder by taking her to this remote location and then driving the shooter away to assist him in escaping. All of that, Judge, should be allowed and should be admissible, Judge, and we are strongly believe that this case is a principal theory case if he's not the actual shooter, and we should be allowed to argue either scenario to the jury.
Okay. Well, in Turner, one of the guns was found underneath the driver's seat, which is where Turner was seated, giving him basically actual possession of a firearm. Let me read on here. So that's a distinguishing factor. I've seen no evidence presented by the state. And if they want to make an argument, and I'm going to instruct the jury that I've already instructed the jury what the attorneys say is not evidence and should not be considered as evidence. They can argue whatever they want.
We should be allowed, Judge, to argue that even if you believe their theory of the facts, it still puts Ronny Walker as a principal to this crime. Even if you believe the defense's theory, which we are not in any way agreeing or advocating or believing in, because there, as Your Honor has said, there is no evidence that Robert Creed shot and killed her. However, there is evidence that at least Ronny Walker, even if he wasn't the actual shooter, did aid and assist the shooter in committing this murder. And that is what the state's sole position is. We believe we should have the right to argue each theory in this case. And there's enough circumstantial evidence to at least take it, if you look at it in the light most favorable to the state, there's at least enough evidence presented to the jury and let them make that decision. And he did not implicate Robert Creed. Judge, all of this is clear evidence that he was assisting and aiding Robert Creed if they believe what the defense says, which is that Robert Creed was the shooter. And we should be allowed that alternative theory of argument. I promise you, Judge, we are going to be arguing strongly that Ronny Walker shot and killed this woman. But when their defense gets up there and they start saying, it was Robert Creed, it was Robert Creed, he's the one who had the connection, he's the one who had the connection, then we should be allowed to get up there and say, you know what, maybe even if it was, what did Ronny Walker do? He drove this 14-year-old girl in the middle of the night to a remote, abandoned location, and then if Robert Creed got out of that car and shot that girl, he then assisted Robert Creed in getting away from the scene. All together. That together, Judge, is a principle all the way.
Do you think that's a real possibility that happened?
I don't think it doesn't matter, Judge. If that's what they argue, we should be allowed to rebut that. That's all we're saying. It's not like we're arguing that that's what happened. We're arguing the opposite. However, if they get up there and blame Robert Creed, we should have the right and ability to rebut that under the principle theory and say, even if you believe with no evidence whatsoever that Robert Creed shot her, Ronny Walker aided and assisted him in committing this murder by driving that girl to that location, by then driving Robert Creed away with the lights off, mind you, clear attempt to help him escape from the commission of this crime. All of that, Judge, combined together is a principle theory.
Why doesn't that make him an accessory after the fact then?
Judge, because we're arguing circumstantial evidence in the light most favorable to the state.
What's your circumstantial evidence?
The picking up this girl, that was Ronny Walker who picked her up.
Okay.
The driving her to this remote location, turning off the lights.
I'm just going to object because it's being said over and over. This is not a remote
Well, I want to hear it again.
I get it. It's not a remote location. It's a neighborhood.
It's a remote location in the court's opinion. It's at the end of a dead-end street in a vacant lot. That's a remote location. And it's just, there's no jury here.
I understand.
I know what he's talking
over and
about.
over again, and it's not true.
Well, Judge, I'm saying this because we can't get into the intent. We don't
You know
what
this reminds me of, and I'm not trying to be cute. Travis Tritt wrote a song called A Modern Day Bonnie and Clyde. If you've ever seen the music video, Billy Bob Thornton picks up a girl at a gas station. She gets in the car, they go off, they stop to get some food on the way. Next thing he knows, she's running out of the gas station with a gun in her hand and some guys trying to stop her. And he takes off. He didn't know what she was gonna do.
Does he take off with her?
He took off with her, but he didn't know she was gonna rob the gas station. So later on, now he likes the idea that they got a bunch of stolen money and cigarettes, so they pull over to count the money, smoke the cigarettes, and the police arrest him. He's an accessory after the fact, because he had no prior knowledge that she was going to intend to rob the store. There has to be some evidence that Creed knew that there was gonna be a murder at the end of that street. Walker had to know
principal
that.
theory, Judge,
And that had to be, how does Creed know what Walker's thinking?
And I believe, Judge, in the light most favorable to the state, and that is what Your Honor is supposed to be doing at this moment in time when it comes
Yes.
to judgment of acquittal, okay? In the light most favorable to the state has proven that a number of things. Number one, Ronny Walker was the driver. Number two, that he drove to this location, okay? There's no reason to take this 14-year-old to this location unless you're planning on doing something bad to her, okay? Number three, he then drives the person, if it wasn't him, which we're arguing it was, but if it was someone, if it was Robert Creed, he then drove that person away to protect him with the lights off, mind you, so that they
No
cannot
question
be picked
about
up.
that.
All of that is assisting, aiding, and abetting. That's what we're talking about. So even if maybe, like, if we want to go off on a crazy tangent and say that Robert Creed did this all on his own, got out of the car and shot her, he still stayed there and helped him escape. Not just successor after the fact, Judge. He had to have witnessed it and then provided him an avenue to get away, which means he was involved and assisted, aided, and abetted this crime.
I don't have any problem with all that argument.
Okay.
I'm good there.
Then he lies to police. He doesn't give the name of Quincy Creed as being involved with him or even there. All of this stuff, Judge, all combined together, we can argue satisfies that intent under the circumstantial evidence theory. We're not arguing that we have a direct statement by him written down where he says, I'm going to go with Robert Creed and kill this girl. But the fact that they were acting, the way they acted together in concert is circumstantial evidence, Judge, that, taken in light most favorable to the state, should allow it to go to a jury question and a jury decision as to whether or not he was a principal in this case, if they want to think or believe that the defense's argument that Robert Creed was the shooter. Judge, it's the state's position that we have sufficient, substantial, circumstantial evidence to at least present that to the jury and let them make the decision as to whether or not that applies. And we are relying on the Turner case, the TS case, the Lewis case, the McGuire v. State case, all of these cases, Judge.
Yeah, I read all of those, and I found a lot of distinguishing factors in those.
Judge, we can always find distinguishing factors. The fact of the matter is when you look at the case in the light most favorable
Well, I
to
think
the
the Turner
state.
case is your best argument at this point, but let me go. All right, I'm gonna take 5 minutes to go read something real quick. Yeah, go ahead, and let the defense respond, so I can take that back with me.
Well, Judge, just as the court pointed out, there was some evidence, be it minimal, but there was some evidence in the case that Turner was in possession of the weapon. And so, again, that is distinguishable from the case that we have here. The state has not introduced any evidence that if it were Robert Creed, okay, that shot and killed Nilexia Alexander, no evidence that Mr. Walker knew what was going to happen. Sure, even if he thought something bad was going to happen, like they were going to go buy drugs and give this 14-year-old girl drugs, or even if he thought something bad was going to happen, like Creed was going to go off into this isolated area and have sex with a 14-year-old girl. Neither of those things are first-degree premeditated murder. The state would have the burden of showing at least some evidence that Mr. Walker was aware that either first-degree premeditated murder, second-degree murder, or manslaughter was about to happen. That is it. And they have not introduced any of those evidence, any of that evidence.
Any response to that?
Judge, only that the evidence must be looked at in the light most favorable to the state. And the fact that this grown man is picking up a 14-year-old girl, driving her to this location at 3 a.m. in the morning indicates all you need to know that they were planning on doing something to this girl.
There's no doubt.
Okay, so if they were working, then he was involved in getting that girl to that location and then helping, if you want to believe, and again, Judge, we are not going to argue that Robert Creed was a shooter in any manner. But then he helped him get away. The shooter was outside that vehicle. The shooter was not within the vehicle, at least not on the shots that killed her. Those shots all took place outside that vehicle, which means that if Ronny Walker was in the car and Robert Creed did all this on his own, he had to know what Robert Creed was doing at that time and then proceeded to help him drive away. So he was now at that point, whether he had the premeditated intent at the very moment, he certainly had it by that point in time. If you look at the evidence in the light most favorable to the state judge, which is what we're asking this court to do, we cannot get into his mind. There is no, he doesn't have a diary where he wrote out, this is tonight I'm going to go kill Nilexia Alexander. But when you look at the circumstances surrounding her death, all things point to that Ronny Walker knew and was involved in what happened to that girl.
The driving away part, that's quite frankly is not even a consideration because that's after the fact, right?
Right, I
Clearly
understand that.
someone's
We gotta
sitting
get to
there-
that point.
Right, exactly. And I sent the court that case law about the difference between the accessory after the fact and the principal.
Right.
So the driving away part does not impugn any knowledge as to what was going to happen beforehand. Certainly, maybe if they wanted to charge Mr. Walker with accessory after the fact, then maybe we would have a different argument or a different conversation, but that's not what he's been charged with. The driving away should not be a relevant factor.
I disagree with that immensely, Judge. The driving the perpetrator, if it was Robert Creed, as they're suggesting, clearly shows he had an intent that this happened, that this crime occurred. And just getting to that location, Judge, we can at least argue circumstantially, this is his car. He drives and picks up that girl, and then he drives that girl to that
I
local
understand your
location.
argument.
I don't understand how that cannot be a principle. That's circumstantial evidence that looked at in the light most favorable to the state, and I get it, and the defense can get up here and argue to the jury day long that, hey, he maybe didn't know what was gonna happen. But then I should be able to rebut that and say, listen, even if he knew, because that shooting took place right outside his car, and he clearly intended to help the person, whoever it was, commit this crime by helping him get away. Plus, he also took this woman to this location, this girl.
Judge, none of these are new arguments. The court has already ruled.
I'm trying to make it clear, Judge,
I'm
that
gonna go
we
look at this
believe
again.
these are all the circumstantial evidence that put together in the light most favorable to the state should clearly at least allow the
I
jury to consider.
understand. We'll be in recess for 5 minutes. Considering the request for judgment of acquittal, I'm now going to reverse my decision to grant the JOA on the principal factor, and these are the reasons. The overriding filter that I'm looking through is that it's in the light most favorable to the state. The driving of the car, the lights being turned out, the car being positioned so that the passenger side, or the driver's side, where the victim was allegedly seated, facing that side. The fact that the shots occurred within seconds of the car being on the scene. And Creed's testimony, which is completely contradictory to the physical evidence about a shot being fired inside the car. There was no round found inside the car, there were no bullet holes found inside the car. Everybody said the windows were up. But where's the round? It wasn't in the girl. And it's more consistent with that shot being done outside than it is inside. In fact, it's more consistent that there were no shots fired inside because no round was located in the car, and there was no, even if the round had been taken out of the car, it would have damaged the inside of the car, and they went over that car. So those are the things that I find favor the state in the light most favorable to the state. So I'm going to allow the principal theory and deny the judgment of acquittal. Having said that, I would ask the defense if you would like an extra instruction that if you find him guilty of premeditated first-degree murder, did you find him guilty of principal or not? Or something to those words on the verdict form.
Sure.
And Judge, I think that's contained within the firearm finding, because I think.
Well, I want it separate. I want to know if they found him guilty under the principal theory or not. So if they, for instance, I have a case pending before me now, I have to send somebody on, where they found the person guilty of first-degree murder. They found his co-defendant not guilty, but they found that he possessed no firearm, shot no firearm, killed no one with a firearm. So now I have to wrestle with that one. So I want to make sure, in this case, regarding what interrogatories they check off, I want to find out if they, and that's only if the defense wants that on the verdict form. And you,
I mean, to be clear, it's not a cure.
Not cured.
We're not waiving
I
an
understand
objection of
that.
that.
No, I wouldn't, I don't know, I'm not asking you to do something that would cure or acquiesce.
We could add the interrogative that is added sometimes for juveniles, asking, did the defendant actually kill Nilexia Alexander?
Or did you believe it was a principal? We'll present one to you,
Okay,
and we'll see, we can always tweak it.
okay.
All right,
Judge, are you gonna provide it then, because I'm,
we'll provide that,
okay.
yes.
So what about?
Anything else?
Will you be adding, the principal instruction back into the instruction?
Yes, I
Do you
am
want to-
inviting it and
Judge,
putting
I'm
it
gonna
back.
walk up, I've got the principal instruction as well as the mere presence at the.
He's
I've
got
got the
that.
principal instruction as well as the mere presence. The one we sent you didn't have
She asked
that.
for the mere presence after that, right?
She did, Judge, and so
Okay.
we're, that contains both those two instructions that were litigated over, so that can be added to the packet. which you-
What, any particular place in this packet you wanted added? After murder, second degree, or in between premeditated and second degree? Or, thank you.
After 3.3D would be good.
Say
Yeah,
again?
after 3.3D. Just before plea of not guilty and reasonable doubt, I know that it won't, under our instructions, it's kind of weird to put it there, but just kind of basically between page 6 and page 7, just when after you get to possession of a firearm and discharge causing great death, then I can call my secretary and have her now print out new copies and adding that in that area.
Could you do that? Because I don't have the
Yes.
new ones that we agreed to.
Okay.
Well, you know what, I think they did come in while I was in there.
She emailed them.
I just haven't printed them yet.
Yeah, they're all emailed, but I can.
Yeah, I got them. We can print those.
I can have her add the principal and mere presence right after 3.3D.
All right, do that.
Original
But
things.
I'd rather have an extra copy than not enough.
Okay, let me contact her, and then she'll email that to you, if that's okay with the court.
That's fine.
All right. Hey, listen, so we need you to put the principal and the mere presence, the one we took out, we need you to put them back in. And can you put them in after 3.3D, but before 3.7, please? Yeah, yeah.
page 7.